Hello friends, I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's discussion is nature of legal resources. Welcome all to today's talk. Dear friends, after going through today's module, you will be able to understand the concept and meaning of legal resources and its various kinds. Dear students, the present module will make you acquainted with meaning of legal resources, primary legal resources, the Constitution as a foundational legal resource, legislation as a legal resource, case laws as a legal resource, international treaties as a legal resource, secondary legal resources and importance of secondary legal resources. So friends, let us begin with the brief introduction of the topic. Legal research is a systematic approach to discovering and comprehending legal data and materials to answer legal questions, support legal points and make informed legal judgments. At its core, it is akin to solving a jigsaw puzzle combining elements of laws, case precedents and expert opinions to find the necessary solutions. To conduct through legal research, it is crucial to pinpoint relevant legal sources, understand their context and then apply the law to specific scenarios. Two of the most common resources attorneys use are primary and secondary sources. Primary resources encompasses constitutions, judicial decisions, statutes and administrative rules and regulations. In addition to restating the law, secondary legal sources may provide commentary, analysis, description, explanation or criticism. All legal information can be described as either primary or secondary. Primary information is legislation and case law. Secondary information helps you find and understand the law. This is an important concept in learning how to approach legal research. Dear students, moving further, now we will discuss the meaning of legal resources. Legal resources encompasses a wide array of materials that support the practice of law, enhance legal understanding and facilitate access to justice. Legal resources refer to the various tools, materials and references that assist in understanding, interpreting and applying the law. These resources are essential for conducting legal research, understanding legal issues and navigating the legal system. Legal resources refer to the various sources from which you can gather information about the law, legal principles and legal processes. Legal resources are vital for gathering information about laws, regulations, legal principles and procedures. They come in various forms and serve different purposes for legal professionals, scholars and the general public. Legal resources encompasses a wide range of materials and tools that facilitate the understanding and application of the law. They are essential for effective legal research, informing legal arguments, ensuring compliance and navigating the complexities of the legal system. Access to these resources empowers individuals and professionals to advocate for their rights and navigate legal challenges effectively. Legal resources can be categorized into several types, each serving specific purposes in understanding and applying the law. Here are some main kinds. First one is primary legal resources, second one is secondary legal resources. So friends, at first we will elaborate primary legal resources. Primary sources are the cornerstone upon which our entire legal system is built, because they provide the earliest and most compelling evidence for the laws, regulations and tenets. These sources are the principal authorities. Sources establish the foundation for subsequent legal discussions, rulings and judgments. Primarily, The judicial system uses primary sources to guarantee justice, equity and consistency. It's like getting right to the heart of the legal system when you can access foundational text like statutes, case law and constitutions. Like historians, legal experts require access to primary sources to completely comprehend the customs and ideas that guide our day-to-day activities. Primary information can be divided into 4 types. First one is constitution, second one is legislation, third one is case laws and fourth one is international treaties. The first one is constitution. The constitution is a crucial legal resource that provides the bedrock for governance, individual rights and the rule of law. Its role in shaping legal interpretations and guiding governmental action makes it indispensable in the legal landscape. The Constitution serves as the guiding instrument within our nation's legal framework. It serves as a protective mechanism for fundamental rights and ideals, requiring all the legislation to conform to these established standards. The establishment of a framework is responsible for describing the processes involved in the creation, interpretation and enforcement of laws. Legal specialists acquire a comprehensive understanding of the complex dynamics of the legal system and safeguard the principles of justice, societal cohesion and individual rights by examining statutes, regulations, case laws and constitutions. The Constitution serves as a foundational legal resource in several important ways, like supreme law of the land. The Constitution is the highest legal authority in a country. Any laws or actions that conflict with it is considered invalid. Second one is framework for the government. It establishes the structure of government, outlining the powers and responsibilities of the different branches like executive, legislative and judicial, and ensuring a system of checks and balances. Third one is protection of rights. The Constitution enshrines fundamental rights and liberties such as freedom of speech, religion, due process. These rights provide a legal basis for individuals to challenge violations. Next one is interpretation and precedent. Courts interpret the Constitution in their rulings, creating legal precedents that guide future cases. Landmark Supreme Court decisions often clarify constitutional principles and their applications. Amendment process. The Constitution includes mechanism for amendment, allowing it to evolve and adapt to change societal values and needs while maintaining stability. Further, framework for legislation. Constitution sets the limits within which legislature can operate, ensuring that laws enacted align with constitutional principles. Legal references. Legal practitioners, scholars and judges frequently refer to the Constitution when making arguments or rulings, using it to support claims and establish legal reasoning. Next one is public policy influence. Constitutional interpretation can significantly impact public policy, shaping issues such as civil rights, health care and education. The second one is legislation. This includes acts of parliament, legislative instruments and delegated legislation. Statutes constitute the fundamental legislative framework of our legal system. They are established by legislative bodies which may operate at the national, state or local jurisdictional levels. Statutes contain many themes from criminal offences to environmental rules. They function as the fundamental basis upon which a legal framework is constructed. like compendiums. They serve as a framework that directs the behavior of individuals, enterprises and institutions, thereby fostering a well-organized and systematic community. Dear friends, moving further, now I would like to discuss few definitions of legislation. According to Salmond, legislation is that source of law which comprises in the assertion of lawful standards by a competent specialist. According to Austin, legislation is the command of the sovereign or the superior authority which must be followed by the common masses backed by sanctions. Further, according to Gray, legislation implies the formal expression of the administrative organs of the general public. Dear friends, moving further, legislation as a legal resource. Legislation is not only a source of law but also a vital tool for governance, legal clarity and societal order. It plays a critical role in the legal system, influencing how laws are applied and understood. There are many purposes for which legislation may be passed, including directing, endorsing, granting, authorizing, proclaiming, confirming and annulling. As a result, the welfare of the people must be considered when passing laws and upholding the rule of law, and such actions must be taken in the citizens' best interests. The legislation serves as a fundamental legal resource in several key ways, like framework of laws. Legislation establishes the legal framework within which society operates. It defines rights, responsibilities and legal standards, helping to maintain order and protect individual freedoms. Source of authority. Statutes passed by legislative bodies like Parliament of India or concerned state legislatures provide the authoritative basis for legal decisions. Courts rely on these laws when interpreting cases and determining outcomes. Further, guidelines for interpretation. Legislators often provide context and intent in the form of preambles or accompanying reports, which help courts and legal practitioners understand how to interpret the law. Further, precedent setting. While the legislation itself is not precedent, it can lead to judicial decisions that clarify its application. These rulings can set important legal precedents for further cases. Updates and reforms. Dear students, legislation can be used to update or reform existing laws, addressing societal changes, emerging issues or gaps in the legal coverage. This adaptability ensures that law remains relevant. Further, public policy reflection. Law often reflects societal values and policy goals. Analyzing legislation can provide insights into the priorities and concerns of the given period. Accessibility and transparency. Dear friends, codified laws are typically published and accessible to the public, promoting transparency in how legal rules are applied and enabling individuals to understand their rights and obligations. Moving further, regulatory framework. Many laws empower administrative agencies to create regulations that provide detailed rules and standards, offering clarity and specificity beyond the broad strokes of legislation. The third one is the international treaties. Dear friends, international treaties are vital legal resources that shape the conduct of nations on a global scale. They provide for the legal framework for cooperation, protection of rights and resolution of the disputes, influencing both international relations and domestic law. To access and understanding of these treaties are essential for legal professionals, policymakers and scholars engaged in international law and relations. International treaties are critical legal resources that play a significant role in the global legal framework. International treaties are formal agreements between sovereign states or international organizations that create legally binding obligations. They can cover a wide range of issues including trade, human rights, environmental protection and security. Dear students, it is pertinent to know about the importance of international treaties as a legal resource. International treaties are critical legal resources that play a significant role in the global legal framework. Here is an overview of their importance and function. Like legal binding force. Treaties create obligations that signatories parties must adhere to international law. Once ratified, they are legally binding and can be enforced in international courts. Further, framework for international relations. Treaties provides a structured approach to managing relations between countries. They help establish norms and standards that govern interactions, promoting stability and cooperation. Further, protection of rights. Many treaties focus on human rights and environmental protection, establishing standards that signatory countries are expected to uphold. This can lead to accountability and protection for individuals and communities. Moving further, conflict resolution. Treaties often include mechanism for dispute resolution, allowing states to address grievances without resorting to conflict. This promotes peaceful resolution of disputes and foster diplomatic relations. Further, guidance for domestic law. International treaties can influence domestic legislation. Countries may need to enact law to comply with treaty obligations, thereby integrating international standards into their legal systems. Further, source of interpretation and precedent. Courts and legal practitioners often refer treaties to interpret laws and assess compliances. Judicial bodies such as International Court of Justice interpret treaties, providing important legal precedents. Further, collaborative frameworks. Treaties facilitate cooperation on global issues such as climate change, for example, the Paris Agreement, and health, for example, the World Health Organization's regulations, helping countries work together to address challenges that transcend borders. Moving further, promoting development and aid. Many treaties involve commitments related to development aid, trade agreement and economic cooperation, fostering collaboration that can lead to improved economic conditions. Dear friends, the fourth one is case law as a legal resource. Case law can be understood as an ongoing interpretation and application of legal principles in real life situations. The development of legal precedent is contingent upon the decisions rendered by courts in interpreting statutes and regulations within the context of particular legal disputes. The judicial system thoroughly examines the factual circumstances, legal contentions and established principles to reach a determinative judgment in each. These judgments establish legal precedents that serve as guiding principles for other cases of a similar nature. Case law consists of judicial decisions that interpret statutes and legal principles. Courts rely on past decisions, precedents to guide their ruling in new cases, ensuring consistency and stability in the law. Courts often clarify the meaning of ambiguous statutes through their rulings. Legal practitioners can refer to case law to understand how a statute has been interpreted and applied in specific context, helping to inform their arguments and strategies. Case law provides examples of how similar legal issues have been resolved. Lawyers can cite relevant cases law to support their legal arguments in court, demonstrating how a judge has previously ruled on analogous issues. Case law is an essential component of legal research. Legal database allow researchers to search for cases by topic, jurisdiction or keywords, helping them find relevant decisions that inform their work. Dear friends, moving further to the next part of this module, that is secondary legal resources. Secondary legal resources are vital in legal research as they enhance understanding, provide context and guide practitioners in applying the law. They serve as a bridge between complex legal theories and practical applications, making them indispensable tools for legal professionals and researchers alike. The analysis, discussions and insights from secondary sources on primary legal writings are invaluable. Researchers benefit from their insight into the law's background, consequences and intricacy. Moving further, legal encyclopedias. First, there are legal encyclopedias, which are references work that explain various concepts and phrases used in law. Think of them as a dictionary for the language of law. Legal professionals and the general public can benefit from the encyclopedias, concise and clear explanation of complex legal concepts. Legal encyclopedias explain complex legal terms and concepts. This aids users in understanding and using legal language accurately, which is crucial in legal writing and analysis. Many legal encyclopedias are regularly updated to reflect changes in the law. They provide current legal information, which is essential for ensuring compliances and understanding contemporary legal issues. They often include cross-references to related topics within the encyclopedia. This allows researchers to explore interconnected legal concepts and gain a more holistic understanding of the law. Legal encyclopedias are designed to be user-friendly, often organized alphabetically or by subject. This makes them accessible to both legal professionals and non-specialists, facilitating a broader understanding of legal issues. They provide foundational knowledge that can inform more specialized research. Legal practitioners can use encyclopedic entries to establish a groundwork before delving into more detailed legal text or case law. Further, articles and journals. Dear friends, articles and journals in the field of law can be compared to a group of experts having a fireside chat. Articles written by academics, practitioners and law students go deeply into topics, including analyzing recent cases and examining new developments in the field. These essays deepen our comprehension of the law by offering critical analysis, contrasting perspectives and novel ideas. Articles in legal journals often explore specific legal issues, case laws or theoretical framework in detail. They provide a deeper understanding of complex legal topics, helping practitioners and scholars grasp implications that might not evident in primary sources. Many legal journals publish articles on recent court decisions, legislative changes and emerging legal trends. This keeps legal professionals updated on the latest developments in the law, which is crucial for effective practice and advocacy. Next one is legal treatise. Third, there are legal treatises which can be considered comprehensive analysis of a single area of law. These publications, written by leading solicitors, examine and explain complex legal topics at the length. They help researchers to navigate intricate legal topics by providing in-depth talks. Legal commentaries. The fourth one is legal commentaries. Legal commentaries provide insightful analysis of relevant statutes, court decisions, and legal principles. Researchers can better understand the effect of legal decisions and developments with the assistance of historical background, interpretations, and explanations provided by legal commentaries. Next one is case digest. Like a curated collection, case digest compile the most significant legal cases about a given topic. Researchers appreciate the concise summaries and highlights of these cases provided. If you are looking for a summary of case law in a given field of law, Case Digest is an excellent resource. Dear students, secondary resources play a crucial role in the legal research by providing context, analysis, and interpretation of the law. Here are some key reasons why they are important. Interpretation and analysis. Dear friends, secondary resources such as legal journals and treatises offer expert interpretations of statute and case law. This helps researchers and practitioners understand complex legal concepts and the implication of legal rulings. Contextual understanding. Secondary resources provide historical and contextual information about legal principles and doctrines. Understanding the background and development of the law aids in comprehending its application and the evolution over time. Comprehensive overview. Dear friends, secondary resources summarize and synthesize information from primary sources. They offer a broader view of legal topic, making it easier to grasp the key issues, trends, and debates within a specific area of law. Further, identifying relevant case law, secondary sources often cite and discuss relevant cases. This can save time in research by highlighting key cases that should be reviewed for a particular legal issue. Legal theory and critique. Articles and books often explore legal theories and critiques existing laws and practices. This critical analysis can inform advocacy, efforts, policy making, and legal reform initiatives. Further, practical implications. Secondary resources often include useful examples, forms, and templates. This helps practitioners apply the law effectively in real-world situations. Further, facilitating cross-jurisdictional research. Many secondary sources analyze and compare laws across different jurisdictions. This is valuable for understanding how similar legal issues are handled in various places, especially in an increasingly globalized legal environment. Dear friends, now I will conclude today's talk by saying that materials used for legal research are generally divided into two broad categories. First one is primary sources and second one is secondary sources. Primary legal sources are the actual law in the form of constitutions, court cases, statutes, and administrative rules and regulations. Secondary legal sources may relate the law, but they also discuss, analyze, describe, explain, or critique it as well. Secondary sources are used to help locate primary sources of law, define legal words and phrases, or help in legal research. In short, anything that is more than the actual law is considered as a secondary source. So friends, with this we will end today's talk. Thank you so much. We will see you in the next module. Thank you very much.